Hi, I'm attorney Andrew Thompson from the Thompson Law Office. In this video, we're talking about collection matters on personal guarantees and loan guarantees. We can talk about this from both the side of the creditor who may be attempting to collect on a debt they're owed, or the debtor who signed a personal or loan guarantee for someone else on a promissory note or other type of loan. When I started my own practice 3.5 years ago, I had the rather frequent occasion to help people who were fairly well off and had tried to do something in the form of quasi-investment, where they were trying to help out a friend or a former employee, someone that they trusted to succeed in business. So they signed a loan guarantee on a personal level. These are quite often referred to as personal guarantees. They're the assurance of payment of the debt or of another. Okay? When you do this as the person executing the personal guarantee, you're doing it based on your own credit, your own ability to pay. This is very important to keep in mind, regardless which side of a transaction you're on. If you don't have good solid credit, if you don't have a strong personal financial statement, you're not a good candidate for a personal guarantee to begin with. So it all comes down to the ability to pay or the ability to collect when the loan goes bad. That said, not only is the substantive issue of whether or not you're able to pay very, very important, but also something called the statute of frauds is important as well. Anytime one person guarantees the repayment of a debt of another, it has to be in writing. If it's not in writing, it can't be enforced. So if you're a principal in a company, or if you're in a deal involving an investment in real estate, and you don't sign a personal guarantee, the creditor has no recourse against you in the end. In other words, you're off the hook when the loan goes bad, at least on a personal level. On the other hand, if you've signed the personal guarantee, you can almost bet that any action to collect on a promissory note or other debt is going to involve bringing you into the case as well. They're going to try to collect the debt from you as well as the company or other debtor involved. When this happens, you've got to consider what the overall circumstances are. Many times it's because the corporate entity or the individual who's the primary debtor are bankrupt. In other words, the collection was commenced, the collection was initiated because the primary source of repayment can't repay and wasn't repaying. So they're looking to the secondary guarantors instead. Okay? At that point in time, you have to understand from a creditor's perspective, it's often very worthwhile to come up with some type of workout. In other words, cash in hand is better than a long-term collection against someone you didn't have a primary relationship with to begin with. On the other hand, from the guarantor's perspective, the same may also be true. Why do you want to be involved in a long-term relationship, a long-term collection matter with someone who's a creditor you may barely even know, if at all? So instead, if the parties can come up with a factor for a lump sum settlement or some type of terms of repayment that are less than the full amount that's owed on the note, it may be the best solution for everyone involved. At the Thompson Law Office, we've dealt with numerous collection matters, both from the debtor side and the creditor side, involving personal loan guarantees. If we can help you with this type of matter, please call us today at 317-564-4976 or find us on the web at www.thompsonlaw-in.com.